Good morning and welcome to our panel discussion of technology considerations and workers' compensation. My name is Jacquelyn Newman. I'm the Judge of Compensation Claims here in Tallahassee, Florida, and I'll be your moderator today. I'm going to start off by introducing our distinguished panel. First, we are joined by Judge Ralph Humphries, a Judge of Compensation Claims in Jacksonville, Florida. He has served as judge in Jacksonville since his appointment to the bench in 2010. Judge Humphries is a founding member of the E. Robert Williams Inns of Court, comprised exclusively of workers' compensation practitioners. He has also been a member of the Florida Bar Workers' Compensation Rules Committee and previously served as a Supreme Court certified mediator. Next, we have Paul Anderson, Esquire, a senior partner in Anderson Hart, PA, based out of Tallahassee, and specializing in the areas of workers' compensation, personal injury, and wrongful death. Mr. Anderson has been a board certified workers' compensation attorney since 1998. He previously served as president of the Florida Justice Association, president of the Florida Workers Advocates, and chair of the workers' compensation section of the Florida Bar. And he continues to be active in those organizations. Mr. Anderson primarily focuses his workers' compensation practice on representing injured workers. We are also joined by W. Rogers Turner, Esquire, a shareholder in the Winter Park office of HR Law, PA. Mr. Turner is a board certified workers' compensation attorney. He is a member of the Florida Bar's Workers' Compensation Section Executive Council, past chair of the Board Certification Committee, and president of the William Wyland American Inn of Court. Mr. Turner's primary practice is representing the interests of employers and carriers in litigated workers' compensation claims. And last, but certainly not least, we have Julie Hunsaker, who is the operations manager for the Office of the Judges of Compensation Claims Central Clerks Office. The OJCC Clerks Office is the central hub for the 17 district JCC offices across Florida. Ms. Hunsaker is the primary manager and tester for all proprietary software platforms used by the OJCC, including Ejcc, the OJCC's electronic filing system, which I think most of us should be familiar with. Julie, I'm going to start off with you on that note. You were kind enough to join us today, excuse me, to give us an update or some pointers, if you will, from the OJCC's clerk's office regarding e-filing.
Thank you. I'm incredibly outclassed in this panel, and I appreciate your the opportunity to speak. Like you said, I'm the office operations manager for the clerk's office, and I have a lot to do with the Ejcc platform and how it works and how sometimes it doesn't work. So if anything I say throughout today raises any questions or concerns, let me know. I definitely want to hear feedback. I'm not the only one out there using it, and so any kind of information I can get, I absolutely would definitely like to get. And so I want to make it usable and friendly to those who use it. Just really wanted to go over that most of you will probably know, some of you may not, and so that's for those people out here. So first of all, in Ejcc, after you log in, there's a menu options across the top. One of those is case filings. From here, you can put in a date range, and you can pull up any filings within that date range for cases that you have appeared on. This is incredibly helpful if technology isn't being as friendly as you would like it to be and emails aren't working, or for whatever reason you're not getting service on something because the server blocked you. Go to your case filings, put in the date frame you're concerned about, and you can check everything that's filed on your cases. Just something that help you keep things moving and hopefully not miss anything. Also, another potential helpful thing out there that some people know, but some people may not, is the uniform pretrial stipulation. There is actually a form that can be generated out of Ejcc automatically, has the case information, has the parties, the issues, all the things. And you can find that by going Ejcc, logging in, putting in the case number, and then if you go to the case schedule and you click on the mediation, this will bring up another page. So it has the mediation information on it, and right underneath it is a button. And that button says create pretrial stipulation. And this is if you hit the button, it'll generate in Word. You can use whatever information is there. You can use the form in its entirety. You can cut and paste your own form, but it's helpful and faster than typing out a lot of this information. Also, in the menu option, one of them is my profile. This is where your name information is. It's your bar numbers listed there, firm information, your password, things like that. And one of the boxes in the profile is called the suffix box. Most people leave it blank, which is totally fine. But if you do put something in it, I just wanted everyone to be aware that there is a character limitation. It's meant to have junior, senior, something like that. So if you put in the word Esquire, it'll let you put it in, but it's going to cut it off. And so you're going to be Joe Attorney, Esquire, which isn't always ideal. So if you do want to have Esquire as part of your name, make sure you put it in the title box and not the suffix box. When filling out a petition for benefits, specifically in the indemnity section, if you don't have an end date, you can just leave that blank. Put all the other information in, the beginning date, all the things. And then when you're ready, click add, and the system will automatically generate the word continuing in the end date. That's something that a few attorneys had questions on when the newer version of Ejcc rolled out. So I wanted to pass that along and make sure everyone was aware of that. So when filing and you have to enter a title for your document, I specifically, but in general, if we could not use all caps, that would be great. And the reason why I say that is because if you look at a docket and it's just full of all caps remarks, it can be incredibly difficult to read. So if you are filing and consider that, I'd appreciate that. Just another tip that I like to pass along because not everyone knows it's out there. So when you have a case pulled up and specifically the docket, on your keyboard, if you hold down Control and hit F, a little box will pop up in your internet browser that allows you to put in a keyword. So if you're on the docket and you do Control F and you type in the word motion, it'll highlight all the times the word motion appears. So if you're looking for something specific, Control F, put in the word, whatever it could be, and it will help you find it faster. I know some cases can just be hundreds of documents, and that little feature could help speed things up instead of scrolling and scrolling and scrolling and potentially missing it. Hit Control F and do a keyword search. For the judges and OJCC mediators listening, you can also do that in Ejcc. So that might help you in the working from home and Zoom world as well. And last, I just want to quickly go over, last year we were able to update Ejcc to include registered employers. So that works incredibly similar to our registered carriers list, which everyone's super familiar with and comfortable with. It works very much the same way. So on the employer page for a petition for benefits or an RACN, you can either enter manually the information for your employer, or you are given a drop-down box. And in the drop-down box is a short list for now, but we're hopefully going to be building that for registered employers. And what that means is if you choose a registered employer, they will get e-service. So once you're done filing the petition for benefits and you enter the service portal, you will see that that registered employer is listed there. And so you can serve the petition electronically. Save yourself some time, save yourself some money. We have, I think, 8 or 9 employers right now. Walmart is one of them, Publix is one of them. We have several others that I don't remember off the top of my head, but when filing and naming employers, it could be beneficial to you to take a look at that list and just see if who you're looking for is there. And also, if you represent an employer who wants to be registered, send them my way. We would like to work with them, get them on the list and help smooth the process for everybody. And if anything I said brought up a question or a concern, or if someone in your office has a great idea for how to make the e-filing process work better, I definitely want to hear it. I am all for suggestions. I can't make any promises, but I absolutely promise to listen and see what we can do to help. And you can reach me at askojcc@doa.state.fl.us or 850-487-1911. And again, please reach out. I know what I went over wasn't particularly earth-shattering or, even interesting, but if it helps someone, I'm glad I got the time to speak with you, and definitely reach out if anyone has any questions.
Well, Julie, just to repeat that email, because when I was a practitioner, I didn't know it existed. And I think it's very helpful. It's actually helpful to the staff in my office. When we have a question about something, we actually use it too. So it's askojcc@doa.state.fl.us. So hopefully you'll get some questions, if any, out there. And Julie, I know we're going to let you go and log off from the panel, but we certainly appreciate your time today. And I think the information you gave was certainly helpful.
Thank you so much.
One thing that Julie talked about real briefly, and this is when the parties are filing, and probably the people watching this need to talk to their staffs about what to do. But one of my pet peeves as a judge in reviewing a docket is in trying to find things. I didn't know the Control S, which is very helpful, Julie. But the other thing is if the title line could be much more descriptive than what we typically see. I'd love to see claimants bar to put claimants notice of filing or deposition of Dr. John Doe or whatever it may be, rather than just notice of filing, which I get too often, or motion to admit medical records. Certainly, and Julie, I assume there's no reason they can't use literally as many docket numbers as they might wish to do, and break those multiple filings down. Instead of filing 10 doctors' records under one, please break them down and put notice of filing medical records of Baptist, notice of filing medical records of Dr. Smith, and so forth, is separate docket entries, because that makes our job much easier in reviewing evidence at trial.
Absolutely. There's no reason why you can't file multiple. As far as I know, I don't believe there's any cap.
Okay.
Okay, well, great. Well, thanks again, Julie.
Thanks, Julie. Good to see you.
Thank you so much.
So switching gears now to what we'll call other technology considerations. I think one of the biggest changes to workers' compensation hearings this year has been the use of the Zoom or other online platforms to conduct workers' compensation hearings. Certainly, it's been a great way to keep our cases moving forward, to get parties together, whether it be for depositions or hearings or other events, so that we don't have a backlog on our cases and clients can get to court in a timely fashion. And so I know I've had quite a few Zoom hearings this year, and I know Judge Humphries, you have as well. What has your experience been like with the use of the Zoom conference to conduct hearings, and what recommendations might you have for making the Zoom hearing most effective?
Well, I've come to enjoy considerably the Zoom hearing. One, it's a matter of convenience, and because of my age, I'm in that advanced or that higher exposure to COVID concerns group, and so I have been working from home a lot. This has enabled me to work from home, not just on routine days, but those days I do have final hearings, although most of the times I'll go to the office for that. But it has been an extremely convenient way, and I think a remarkably good way, an effective way for us to continue our caseloads, where our brethren in the courthouses with their civil cases and criminal cases are not having the luxury that we have of being able to continue. And while there was a backlog initially, once we were getting used to dealing with COVID and the implications of that, certainly this has enabled us to maintain a constant movement of our cases to meet 210-day deadlines and so forth. So I have found it quite effective. In terms of dealing with it, I think for the practitioners, the main thing is they need to treat it just like they were appearing in my hearing room. I've had one lawyer appear in a polo shirt. I was a little taken aback by that. I think it's still an occasion that a coat and tie for gentlemen and appropriate attire for the women is. I'm old fashioned. Call me silly, call me obsolete, but I think that's an appropriate way to do it. Not in a polo shirt. The witnesses certainly have a greater latitude, but I do think that our attorneys should be still projecting a professional image. The only thing I think I've really noticed in terms of Zoom, because just as we're doing right now, everybody seems to be looking at me. They aren't sitting at a table looking or right next to each other, where often their comments tend to be addressed to the side, to the attorney that they're dealing with, and they're dealing with me. We have limitations of one person speaking. And so sometimes those objections get lost in the shuffle. When you're having those problems, I do recommend people raise your hand. I've got an objection, or just somehow make it known. I've heard one judge recommend that people, one of the AJCs has recommended people actually make a little sign that says objection, hold up, something like that, simply so that your objection can be made aware, because sometimes we simply don't hear it. But in terms of etiquette and the things that we should be looking at from that perspective, those are the kinds of observations I've had.
Thank you. Mr. Anderson, I'll turn to you. From a claimant's attorney's perspective, what has your experience been like attending Zoom final hearings, and what additional preparation is required to get either your client or your other witnesses prepared for the Zoom hearing?
Well, as Judge you've experienced and Judge Humphries has experienced, I tend to want to be live. So I honestly haven't done a Zoom final hearing yet. I've done several where one side is live and the other is not live. And I've done with Judge Humphries one that was completely by telephone. I do think it is important, though, and I can see the utility of this when you have witnesses who are at a distance, where it's more difficult to call people to come live, or where the economics for individuals don't justify it. So I can see the utility. I think in addition to what Judge Humphrey says about attorneys, it's important, if you're going to have your client appear, whether it's the claimant or the claims adjuster, that they should be as appropriately attired as is possible, because you are presenting yourself to the court. And you want the court to have a positive sense of who you might be. I think it's the attorneys, even more so for you, Your Honor. It's important for our clients to know that we dress like professionals and conduct ourselves in that manner. So that aside, I'm welcome and open to Zoom hearings. I think they're great. Opportunity. I've learned that through all the depositions we're now doing and all the conferences and motions and the like by Zoom, that this has a real utility that seems to be something that will last.
I agree. And we'll get to that in a little bit, whether we think it's gonna, whether it's here to stay. But before we do,
I'm sorry.
that's okay. Mr. Turner, I'll ask you the same question from the perspective of counsel for the employer carrier. What has your experience been like, and what recommendations or advice might you provide for successfully navigating these online hearings?
Well, I had one this morning, and it was really my first one, and I'd give it a C for my part. It's tough, I think, in a couple of ways, because the attorney on the other side this morning, his microphone was not especially loud. And so I found myself leaning into the computer the whole time to try to hear exactly what he was saying. You really want to get someone that, if you're less experienced, I think you really want to get somebody that can show you how to do the document share if it's an important thing to do, because you do not want to try to be holding documents up to the camera, or otherwise it's pretty easy. I had one of our younger associates in about 10 minutes show me how to do it. And it's not really hard, but the judges should like it because it forces you to become more prepared. It forces you to think, okay, well, I think I'm going to impeach the claimant with this document. I need to have it up where everybody can see it. So the good thing is that a lot of things are on the docket. You can refer to things, but it's not the easiest thing in the world to try to go back and forth between the OJCC docket when you're actually participating in a Zoom hearing. So, spending a little bit of time prior to the merit hearing, getting the top 10 or 15 documents you think may come into play and may be important up on your, saving it on your home screen. And that way Zoom can access it directly on and let everybody look at it. It really makes a big difference, I think. I think for purely legal matters, when the attorneys are talking to the judge, I love Zoom. I mean, you're right, Judge. Everybody's kind of looking at the camera. You don't get a lot of the people trying to talk to each other and talk, not use you as the focal point. And we had a relatively soft-spoken claimant witness today that also was a little difficult. So those are things that I don't love about it, just because it's difficult in that respect. But I think if you get your act together and get everything together, I will say, just to finish up, even with the documents that I loaded onto the desktop, my desk was still piled up with a bunch of things I had to print off because I got scared that I wouldn't be able to do it. So, don't I guess be bashful about getting your most important things right at your fingertips also.
And I will say I had a Zoom hearing recently where when it was just the two lawyers and I on the call and going through exhibits, one of the attorneys indicated that he planned to use the screen share later in the hearing, and he wanted to do a trial run to make sure he could do it. And I was fine with that. And we
Sure.
gave him a moment to see if he could make it work, and he made it work. And so, so I'm sure, just as I was willing to do it, I'm sure other judges would be willing if you're not sure exactly, how to do it in real time. I'm sure you could do a little trial run like that as well. And also during my hearing, someone was able to pull up the docket and screen share the docket, so we could all look and see exactly, what documents were filed under what docket ID number. And
That's
so
my next. I got to write that down for my next tutorial. So
I thought that was helpful as well.
There are a couple other things, if I may,
Go ahead.
that both attorneys have commented on that I think, these participants in our seminar will find that the judges are very accommodating. We're learning as well. And some of us may have had more experience than I'm surprised, and I just see that I've cut out again that you can listen to me but not see me, which is best. But in any event,
We're giving an example of how to push through if your technology isn't working perfectly in a Zoom hearing.
well, and this has happened to me, not so much with the appearance stake, and here I am again, but I've had where, just as was indicated with Mr. Turner, one of the parties was soft-spoken, and it may have been their connection, just as I seem to be having connection problems today. I've learned a couple of things. One, I typically reboot my computers beforehand, particularly when I'm at home, because it clears cache or memory or whatever it does that seems to help. Two, if somebody in the reverse of what's going on with me, you can hear me, but you can't see me, or you can see me but can't hear me, there I go. There are phone numbers with the invitations that we send out, and people can call in literally and be heard but not seen that way. Or in one case I had, the individual was seen in one screen and heard in another, so to speak, so that their presence was there for all of it. But the judges are accommodating. I've had a claimant appear in my office because he didn't have any kind of a phone or equipment that would allow a Zoom appearance. His attorney was in mid-Florida. The defense attorney was wanting to appear by Zoom. And so the claimant was the only person that was in my hearing room actually participating in the hearing that way. I've had attorneys appear by phone and others live and in person. And again, I think the judges are willing to accommodate those types of things as necessary. The main thing is we want to make things happen and get the case heard. And I'm going to try and fix me again. Thank you.
Well, thank you. And sorry about your technology troubles, but while you're working on that, I'll turn back to Mr. Anderson and ask you that question that had come up earlier, which is, now that we've been in this sort of COVID crisis for almost a year now and have gotten so used to either phoning things in, doing Zoom conferences. I know I've had a smattering of live appearances for hearings and other matters. So the question is Zoom here to stay? Is this something that's going to go by the wayside once we get this, get out from under this COVID cloud? Or do we think it's something that people are going to want to continue to utilize in the future? And so, Mr. Anderson, I'll start with you on that.
My guess, and of course it is just a guess, will be that Zoom will continue to have some utility for what we do. We've always had the ability through DOA to do these hearings where Judge Newman or Judge Humphries, you've handled a case coming out of Miami or some other district. I don't know that we're going to need that service, and we could probably save DOA some money by simply using Zoom. For hearings, it seems to be perfectly appropriate. I don't know that we necessarily need it when y'all are just handling a motion matter or something along those lines, because telephone is certainly adequate enough for me and for Rogers to be on a call with one of you over some case. But when it comes to a need to show a witness and establish credibility of that witness or lack thereof, Zoom is uniquely positioned to do that at a very economical price point compared to having people travel live. And if you have a practice like mine that stretches from Pensacola to Jacksonville down to Orlando and Tampa, there's a lot of time on the road where Zoom could really have a utility for me as a practitioner.
And so, Mr. Turner, I'm going to ask you that same question. I know you have obviously more business and corporate clients. And, in any kind of businesses are generally looking to save money so that they can increase their profit level. So I guess in thinking about it that way, what are your thoughts about whether the employer carriers are going to want to continue to use Zoom technology either for hearings or other litigation events?
Oh, I'm sure they will like that. I think that's a cost saving mechanism. It's interesting too. It makes me think about the way cases are doled out around the state and who gets these cases to file. And now if people are all over the state, but it doesn't really matter where they are, you judges are probably seeing practitioners from outside of Leon County, far afield, and people that have no real connection to Duval County having cases. And I'm sure you had it to an extent before, but it kind of breaks down a lot of these geographical barriers. We have kind of a statewide practice. So we've always said, we can be wherever you need to be. But, now it's a little bit different because as long as the local experts and things like that, there's really nothing prohibiting you from prosecuting or defending cases anywhere in the state. One of the things that I would be interested to know is if you guys ever see or will see is, sometimes there's a big deal made out of, subpoenaing people to come live to trial. Well, there's no more hammer of that if everybody's on Zoom, unless there's some compelling reason to have somebody come sit right in front of you. So I don't know. Have you guys encountered that at all? Either of you judges?
Not really with the subpoenas. I mean, my take on this is I want everyone to be comfortable, especially right now when we're still in kind of the thick of this COVID virus and people potentially being exposed if they go outside their home. And so, I'm trying to listen to the parties and let them tell me how they would like their hearing conducted. I've had attorneys locally who say, I still want a live hearing. I want you to see my client. My client wants to see you and feel like they're having their live hearing. And in those cases, if there's just a few of us coming to the hearing, then I'll use my courtroom. I have the benefit of being here in Tallahassee next to the Division of Administrative Hearings, where we have some rather large courtrooms. So I have used those large courtrooms to accommodate more people. I've asked the attorneys to stagger their witnesses coming in during the day, just to keep people in their car until it's their time to come testify. So I've tried to accommodate people who still want that live hearing. And then, of course, there's some people who don't want to leave their house. And I certainly can sympathize. You never know what, comorbidities or pre-existing
Sure.
conditions people are dealing with. So if someone says they prefer the Zoom hearing, I try and get both attorneys on the line before the hearing to discuss how we're going to conduct the hearing. And of course, during these times, I'm going to be cognizant of people who would rather either I've had a telephone hearing when it's just an issue of medical bills, or some small issue. We've had telephone hearings, and of course we've done the Zoom hearings. And, my hierarchy would be live is best, Zoom is the next best thing. And then, the phone call hearing, but like I said, that also works fine in some instances. So,
Sure.
and I assume that will continue in the indefinite future because we're not going to have a magic date where COVID is gone and, everyone can just move about. So I think this kind of analysis will continue with me anyway, as far as how we're going to conduct hearings and trying to take everybody's feelings into consideration. Judge Humphries, did you want to comment on that? I know he had kind of posed the question to the judges.
I do agree. I think the consensus is live is best, and certainly I think that is where we should be trying to accommodate people when we can. But this to me presents another tool in the toolbox. It's something that we can use. This is not necessarily an exclusive tool. We can use this as an adjunct to a live hearing. For example, the claimant who has moved to Columbus, Ohio, and doesn't have the money to travel to Jacksonville or Tallahassee or Orlando for a hearing. The claims, the national account that the corporate office is in North Carolina and the representative wants to appear at the hearing, not necessarily as a witness, but to be part and parcel to it. We can be having the live hearing and certainly still have Zoom accommodations for that. So I think it's something that as time goes on and we learn what it can and can't do, how we can use it to help serve our clients better, which is the people of the state of Florida, the better we can do that and the better we can accommodate them, make them feel part of the process, then I think we have added to the appearance of doing justice and doing what's right in a particular case.
May I ask the judges a question? How would you recommend we as practitioners address that? I have a claimant who lives in Texas. Should I request that he or she be allowed to testify by Zoom? Should I put that on a pretrial? Just so that we're not in a position where the other side can say, well, we didn't know they weren't going to be here. How would you suggest we handle that?
One of those two ways. I would, I won't give any kind of indicative predictive ruling, but I'm going to accommodate somebody, whether it's the claimant or the employer carrier, to not make them be inconvenienced, but still have an opportunity to be part of the hearing. I can't imagine the circumstance, but yes, I think a motion that says I've conferred with opposing counsel and they say sure, or they say no, and if necessary, we can have a hearing on it or have the judge rule on it, whatever may be appropriate, or simply listing it on the pretrial conference. I do agree, notice in those circumstances would be certainly avoid surprise.
I mean, I guess the answer is whenever you have a question or a concern, to bring it to the judge's attention, the best way is to file a motion. I've had many parties file motions for so-and-so to appear at the hearing by phone, for the attorney to appear at the phone. And that way it gives the other side notice and it lets the judge know whether the other side objects. I've also had parties, request a status conference. I'm usually amenable to those requests. Those can be done by telephone. And like I said, if I have a final hearing on my calendar, usually the week before, I'll take a look and I might even ask for a status conference myself just to confirm how exactly are we conducting this hearing. So I think all those methods are appropriate. Judge Humphries, next question I'm going to ask you. One big thing in any kind of legal proceeding, but especially in a workers' compensation case, is the credibility of either the claimant or even the employer or any other witness that comes before us. And so I've heard judges discussing this issue is a credibility determination of a witness a tougher call if you have the party by a video instead of live in your hearing? What are your thoughts on that?
I think this goes back to my preferences live, and that I've been an attorney, I think about it's too long, and as a judge for over 10 years now, and there's something about being able to see all of the body language that you can grasp when they're sitting 15 feet away from you much better than on certain stamps like this, where you can see just basically the neck up. We have done many of the hearings by VTC, which I think is a little bit better than Zoom, simply because in those situations, I get to control the camera. I can pan in or pan out on a witness to get a better perspective of body language and things of that nature. So I do think it isn't as good, but it's darn good. I mean, you can still evaluate how the witness is answering, where what they're looking at, whether they're looking for help from the attorney on their side or doing any of those things that might be construed as body language or indicative of falsehood or not falsehood. So yeah, live best. I guess VTC would be second best, and Zoom's a close third. But again, I have found it to be still a means by which I can make credibility determinations without, I mean, always be right, but I make those determinations one way or the other.
I've had another judge suggest to me that when the claimant is testifying at a hearing by Zoom or any witness for that matter, that, and I think this could be helpful in depositions as well, is to say on the record, I'm putting the witness in full screen view. So instead of, as we're being presented now with the four of us on the screen, you can change the views so that just the whoever's speaking is really on most of your screen. And that way you can focus on that one person. And again, if looking at them and seeing how they're speaking is a part of the determination, then you would maybe at least have that in better focus than having the gallery view. So that was one suggestion I'd heard, and I think that could apply for depositions as well, when you have multiple parties on a deposition and being able to focus on, let's say, the claimant who's being deposed. That was just a suggestion. And so I'll turn it over to Mr. Anderson and Mr. Turner now. I know that we've been focusing on Zoom hearings, but I know that Zoom and telephone technology is being used for depositions and other litigation events, private mediations, for example. And so I'll ask you, and I'll start with you this time, Mr. Turner. What are you seeing as far as Zoom depositions, or are you seeing more phone depositions, or are any live depositions going forward at this time?
When we first got on the Zoom deposition trail with claimants, I was skeptical, and I had a lot of interesting interactions with claimants doing Zoom from their phones on the way to Home Depot, running errands, doing all kinds of things. To me, it was distracting. I don't think anyone needs to see me during a deposition. So I kind of quickly said to my assistant, you know what, these are all fine on the phone for me. I don't need Zoom unless it's, something where someone has a very specific injury that would help to see or something like that. So, and the same with a doctor deposition, unless I'm going to present the doctor with documents, I'm just as good doing a deposition on the telephone. Although now that I'm more, I guess, a little more learned about what to do with documents, maybe a doctor depo wouldn't be so bad after all. But and then the private mediation thing is kind of an interesting issue. I didn't really think about doing a private mediation on Zoom until I had a claimant attorney suggest to me that it was a good way to make sure that the claimant agreed with what was going on when you hit record on the Zoom mode. Assuming you tell them, of course. I don't think you should do that, but it was interesting to hear her saying that it's one way that I can ensure that all the terms were explained, everything was on the table, they knew what they were getting in their pocket. So if there was ever going to be a question about maybe they were going to be skittish or try to back out, it sounded like a pretty good idea to me. But other than that, I don't personally have a need to do a Zoom on private mediation unless it's just the opening where I feel like a face-to-face might help.
And so, Mr. Anderson, I'll ask you the same question. Are you conducting a lot of your claimants' depositions by Zoom? And what about other just depositions if you feel the need to depose the adjuster? How is your scheduling going these days?
Well, the answer is yes and yes. Historically, my experience has been that defense counsel, when they want to depose the claimant, want to actually see the claimant, especially that initial deposition. And in our areas, as Judge Newman knows, we have a lot of defense counsel who are from out of the area. And so for them to come up for an hour and a half deposition is an entire day on their calendar. Zoom has solved that problem. Now, I do think it's important as a claimant's attorney, if your claimant is being deposed, that you make sure that they're not sitting in the parking lot of some shopping mall doing their deposition, that they're actually some stationary place. Because I've had the problems that Rogers has experienced where the phone is moving around and they can't quite get it together. So we try to prepare them for that. Just before we got on air here, I did a deposition of a witness with an employer who is expected to testify live at hearing. It was good for me to be able to see that witness and get a sense of how she might present at hearing. Adjusters, and this is something we discussed preparing for this, many adjusters now work out of their home. They don't want a court reporter or attorneys in their home. Zoom helps them solve that problem by allowing us to see that adjuster, make sure that they're responding appropriately and doing what we need them to do, and yet not invade their privacy. So I think however much it stays for hearings, I think it's here to stay for discovery purposes.
I have a quick question, judges. Would there ever be a time when you would consider reviewing a recorded Zoom witness depo versus reading the transcript? Has anybody asked, I guess, and could you ever see a situation where it might be more probative to view a recorded Zoom deposition versus read the transcript?
I have not been asked to do that yet. I'd certainly be willing to. Obviously, if there are credibility issues and it was perceived that being able to view the witness would assist in my determination of credibility, yeah, I'm willing to do that. But again, I have not been asked to do that.
I've actually had that come up once before. I don't know if it was because of COVID concerns that the witness was deposed before trial, or if it was just a matter of, I believe he was out of town and maybe it was just for the convenience of the parties. And it was a credibility issue. This witness had witnessed the accident. And so both parties actually wanted me to consider not only his testimony, but wanted me to be able to eyeball him basically. And in that case, I think I both read his transcript and I watched the video. It wasn't too long. Yeah, I was perfectly willing to do that. And I think it was at least somewhat helpful for a determination of his credibility.
That's good. Thank you.
And I'd just like to add, while we're talking about depositions, this is not really a Zoom topic or telephone topic, but I always make this spiel when we get on the subject. When y'all are in the midst of deposition and somebody's complaining, rather than certifying questions that you have to have a ruling on later, and then perhaps go back for a follow-up deposition, I am more than willing to get on the telephone if I'm available, call my office during the middle of the deposition, say, Judge, we've got a problem here. Here's the question, here's the objection. And I'll rule on the record right there, and y'all can go forward with your deposition and perhaps save time and money for everybody. Sorry, had to throw that in.
Judge Humphries, have you encountered issues with parties having disputes over how a deposition will be held, be by live or Zoom? I mean, I've had the situation where someone wanted to record someone via Zoom and that person didn't want to appear by Zoom. I guess they wanted to phone a depo instead. And I've also had the situation where someone wanted the claimant to appear live and that person was reluctant to do so because of COVID concerns. So have you had that come up? And if you were presented with those situations, what would you do?
I have not had that come up, and obviously it's going to depend on the circumstances. I'm very sensitive in part to my age and personal concerns about COVID exposure. I'm not going to put anybody, my knee-jerk reaction is I'm not going to put somebody in a position that they're uncomfortable with in dealing with COVID. At the same time, I think that there is an obligation to see that cases move forward. And I can see circumstances where I may allow video, whether it's Zoom or other forms of video, to allow somebody to be seen if I'm persuaded that there's a reasonable and legitimate necessity of it. I can see requiring it, but I can't define the exact circumstances that may require it, and that might be improper to do anyway. But yes, I think I haven't had that yet.
And then my next question about deposition is and maybe this is best for the attorneys, but have you had problems with the swearing in of witnesses at either your Zoom depositions or by telephone, meaning anyone objecting to either the court reporter swearing someone in over the phone or by Zoom? Mr. Anderson, I'll start with you.
I think every time I do one, the court reporter changes the way they're going to swear somebody in. Sometimes they read one statement, sometimes they read another. Earlier today, the court reporter read the 60Q rule under 6.116. They always ask us to stipulate. I've never had an opposing counsel or myself, argue about that. I think most of us just want to get our depositions done, and we're willing to accommodate that. And, right or wrong, before this COVID and the Supreme Court's ruling, we often agreed on that, everybody being sworn in and under oath, regardless of how the deposition was taken.
Right.
So I think that's a credit to our bar, that we would not come and bother you as the judges with something that I think is ministerial that we should be able to solve as practitioners.
Right.
Mr. Turner, do you want to add to that?
No, I feel the same way. I mean, even if it's somebody I have no idea about, I guess I'm just going to take it on faith usually. Unless there's just a massive fraud being perpetrated by everybody, and I'm just the rube that's going along with it. But yeah, that's kind of not really big on most of our radars, I don't think.
I read something where actually, rather than the attorneys having a problem, a court reporter, because of their rules and statutory requirements, had
Yeah.
issue with it. And I can't recall how that was resolved, but some of what you're getting perhaps is simply the court reporter's interpretation of how they need to proceed in order to be legally and properly swearing a witness.
Well, some of them are, for instance, in claimant depot, requesting our client hold his or her license up to the screen so that they
Right.
can compare how they look. And that solves the problem, of course, too.
Right. Well, and if we're stipulating, I mean, go ahead, then we're just taking a recorded statement. But for our purposes, no one's going to wander in front of the JCC and say, this is a improper deposition, you can't use it. So,
Oh, you'd be surprised.
I would hope not. I would hope not. So,
Judge Humphries, getting back to some of the logistics of the Zoom hearing, when you're having a Zoom hearing, are you using your waiting rooms as far as if there's a witness who's going to be called to testify, but they're maybe the other side doesn't want them to sit in on the whole hearing? Are you keeping them in a waiting room? Are you waiting until it's their time and then inviting them to join the Zoom hearing? How do you handle that?
Thus far, I've not used the waiting room, although it's a wonderful tool just for that purpose. What I've done when there are witnesses, and this was with the agreement of the parties before we even go on the record, I'm told that witness John Doe is going to appear by telephone or whatever it may be, then I typically just have them call in when we're ready for them. So I have not had to deal with it, but I do think the waiting room would be a great tool. I think all but one of my hearings has really been just an employer witness, employer carrier witness, and a claimant, as I recall, that have been Zoom hearings.
Mr. Anderson, any experience with that you wanted to share?
No, but I would think usually I'm going to want to show up with my client, and obviously whether it's live or Zoom, I'm presenting my client. It'd be hard to prove my case without it. But there are a lot of times that I can see the benefit to Roger's clients where they have an employer witness who may be more difficult to get there live, and the utility of Zoom being available to accommodate that need.
Well, and I've had hearings before where I just will start off with just the two attorneys, and we'll go through the preliminary matters, marking of exhibits, and then we'll discuss whether we want to do opening statements, and at what point do you want your client to be in the hearing, witnessing everything, and potentially testifying. So those are all good tools to use to sort of successfully and effectively get your hearing done and not have it drag on all day, I guess.
I used to, like Judge Rush used to refer to that as housekeeping. That needed with the attorneys before.
Yeah.
Okay, so I think we have covered most of the topics today. Mr. Turner, anything more to add about Zoom technology and workers' compensation? I'm assuming that your clients are used to using Zoom for other business meetings and are probably old hats at it by this point.
Yeah, I would say I don't really communicate too much with clients on Zoom. It's mostly phone and email and texting. But of course, yeah, in their setups for what they're doing. Just going back to what we opened with, I'm just really thankful that the DOA website and the OJCC website is so user friendly, because I've been doing this long enough. I remember when they said they were going to start putting everything online, and I was somewhat skeptical because I thought it was going to kind of be a train wreck. But what they're doing with everything and downloading things and making it easy to find things, it's really good. And if you have any friends or colleagues that do any federal work with the PACER system, at least we're not paying for things. We're not having to go pay 30 cents a page or whatever it is to download documents and all that. So I'm really thankful that helps to kind of streamline some of this other stuff we've come into in the last year. So those are kind of my thoughts.
Mr. Anderson, any parting thoughts or comments about technology?
I'll follow what Rogers has said. I think the OJCC platform is the best one out there. And I deal with the circuit court, appellate court all the time in their platform. This one is as perfect as I could imagine it being. It will be better as we get more employers to sign on. But it is user-friendly for somebody like me who's not necessarily the most technologically savvy person in the world. But if I can do it, I figure anyone can do it. And the platform allows for that.
Judge Humphries, any parting thoughts?
Well, I certainly agree with the attorneys. Again, as I said earlier, we have stayed current despite what has happened with COVID. And I think Judge Langham, what he's done over the years has been phenomenal. Judge Cohen, when he was the chief judge, his assistants, people like Julie Hunsaker have made it just a tremendous technology and kept us not only abreast, but way ahead of the curve. I would suggest to our listeners here today, Zoom is a free account. You can get 40 minutes for free. If you don't know how to use it, open an account, practice. You can practice how to share screen and things like that. I have done it, and it's really very user-friendly, quite easy to do. Put something up on your screen and do a share screen, and it's quite something you can make available. Practice with it, and because it is something we're going to be as part of our tools in the toolbox, so to speak, for years to come, I think.
I think so too.
Well, thank you all for joining us today. I appreciate your time and efforts in putting this panel together. Also want to thank both Judge Langham and Judge Walker for inviting us to participate and putting on this annual seminar, which I think is so helpful and so nice to be able to get some CLE credits in workers' compensation for us workers' comp practitioners. So I think that being said, again, thank you all, and hope everyone enjoys the rest of the seminar. Thank you.
Thanks, everybody.
Be good.